It's like the feeling you get when you realize the people who stand behind you are just waiting to push you down a flight of stairs. Welcome to Greater Good Radio. I'm Bob Kosh, and on our show today, we are going to do something that is dramatically different from anything you've really heard on talk radio. I think the issue that we're going to discuss is extremely important when you consider crime and consequence. Now, notice I did not say crime and punishment. This is an all too familiar American story where a youngster around the age of 12, suffering from a broken home, finds himself in the streets. The bad judgment that goes along with that and its consequences are very much the focus of where we are going here. A young life without proper guidance so desperately needed for a young person, for development and the way he or she will see the world. This is a true story, most of which you will hear comes from transcripts of the proceedings of this criminal matter, but how this story comes to you is extremely rare. I was housed on B Unit at Northern State Prison from 2015 through 2019. When you're received in a facility like this, you're assigned a housing unit. The environment you enter includes contained units of over 70 inmates in two-man cells. You are mixed with all types of people and individuals who have sentences ranging from a 3 flat to people finishing up a life sentence. Many that you're housed with suffer from mental illness. Why they do this and how it makes sense, I have no idea, but that's a discussion I'm sure we'll touch on another show. While I was there, and I was fighting my case, I met several individuals, including one in particular who was my next-door neighbor. His name is Kevin McCrae. McCrae, who they call V1, worked in the education department, and he still does over at Northern State Prison. He was the tier rep during my time there. A tier rep is the guy who you go to if you need a request slip to see somebody, or if you need toilet paper. It's just things that the housing officer is not responsible to address. Kevin and I got very friendly. We worked in the same building where the law library is located, and he ultimately told me the details of his case. On December 1st of 1994, himself and 2 other young boys under the age of 18, McCrae himself was just past his 18th birthday. Remember, I talked just briefly about bad ideas. They decided they wanted pizza, but they weren't going to pay for the pizza. So they ended up calling a place who would have it delivered. McCrae called the restaurant and gave the delivery information to the dispatcher. That done, McCrae drove his bicycle a few blocks away and asked the others to, quote, save him a slice. There was never any discussion about the incident as a violent encounter. It was actually, I can't say it enough, just a bad decision where this is going. When the driver got there, an argument ensued, and the young boy who was with McCrae, or one of the young boys, I should say, shot the delivery man in the chest. 19-year-old Wole Oyewo was pronounced dead at the hospital as a result of the gunshot wound. The 3 were arrested and charged with murder. Charges for robbery, felony murder, and possession of a firearm were also included in the list on the complaint. The boys who were under the age of 18 ultimately took plea bargains, but Kevin McCrae decided to go to trial based on what the indictment stated were his operative acts related to the trio when the driver was shot. He thought that because he was not actively involved in the event and he was actually quite a distance away when it all went wrong, that he never contemplated anything to the magnitude that would reach to the level that happened. I mean, the poor guy got killed. What McCrae would find out, although he entered a plea of not guilty, under New Jersey criminal law, conspiracy and accomplice liability would bring him into the case and make him equally as responsible as it related to the crime itself. After a trial in October of 1995, McCrae was found guilty and given a life sentence with a mandatory minimum that he serve at least 30 years before he would be considered for parole. I did not meet the kid who made that awfully bad decision the night in December of 1994. The young man that I did meet, after being incarcerated for well over 23 years at that point, is a well-mannered, educated, God-fearing individual. Moreover, when he and I have spoken on numerous occasions, I have never met anyone who's expressed more remorse on so many levels. He shared with me what he had in his head and in his heart, and having decades to reflect and understand the pain the victim's family has suffered all of these years, and nothing can change what transpired. This is what it is. So this is what brings me to today's topic. After much research and actually consideration given current case law with respect about what we know, what we've educated ourselves about the brain of a young person, we know that not all of us automatically think or turn into an adult, although on your 18th birthday, the law says, okay, you're an adult. McCrae was just over that 18-year marker. He was left to the streets at a young age without really having the chance to have matured or arrived at that point where your age says you're an adult. We will discuss what it means to be sentenced as an adult when there are certain safeguards in place which guide the courts in determining a fair sentence and what is to be considered when imposing that sentence. It is not crime and punishment. I mentioned this before. This is crime and consequence. And when I raise the word consequence, I do not mean the ultimate punishment as a life sentence, but consequences on society, the family, and obviously the person who will end up doing all that time. The actual shooter in this case, or the kid who pulled the trigger, ended up serving 8 years for his actions. He was a child. And this is where it gets a little sticky. It's where I'm at the point now I would love to hear from our listeners about what your assessment is at the end of the show. Email me, call me. My point here is an issue for what they call under the law as collateral estoppel. Its legal definition, in very remedial terms, it means that the state or government has already made decisions which detail that the immature brain of a child cannot adequately make a determination that an adult would when it's related to possess alcohol. There, you've got to be 21 years of age before you make the decision if you can get drunk. Because the state has already set that forward, or actually put that into law, it is a benchmark for where we should start in examining this issue. How could someone who is not old enough to buy alcohol, to do certain things under the law until he is the age of 21, be exposed to a life sentence? We're going to be asking the court to address this issue and resentence McCrae as a youthful offender. It is a novel issue. It's unique, but there is case law, and I'm going to say the climate of the courts have changed with respect to what someone does, and they are still a child. Once again, I don't mean to just bang you in the head with this, but my whole point is here. We don't all mature at the same time. All because I'm 18, I may not understand clearly the consequences or even the actions involved in certain subject matter. And this is where I would like to introduce my first guest, Gregory Aprile. He has been a defense lawyer in New Jersey for well over 30 years, and I got to see Greg on his feet during cross-examination at a trial a little over a year ago. Thanks for being on Greater Good Radio, Greg. Tell us a bit about yourself, what you do, who you are.
Yes, Bob. Good morning. Good morning, everyone. My name is Gregory Aprile, Aprile. I am an attorney at law in the state of New Jersey. I've been practicing now for 45 years. My practice consists mainly of criminal law in both the adult and juvenile field, and of course in municipal court matters also, and some family law matters. I've got a lot of trial experience through my work, first of all, as a private attorney, and also through the services I provide to the public defender's office. I've had probably approximately 250 jury trials, criminal jury trials over the course of my career.
Well, Greg, today we want to focus mostly on sentencing issues, punishment. Over the years, what have you seen? And I'm going to go back, let's say, to the very late 1970s when the state of New Jersey initiated the new Criminal Code 2C. What impact did that have on sentencing once it was introduced all those years ago?
Yes, that kind of coincided with my starting to practice law. The old Title 2A was superseded by what is known as the Title 2C. To be honest with you, Bob, as far as sentencing is concerned, immediately the change in the statutes to the 2C statutes didn't significantly, to the best of my knowledge, like I said, I didn't do much under 2A, didn't significantly change the sentencing structure. Subsequent developments, though, of course, have changed the sentencing procedure.
Now, with respect to due process violations, with respect to disproportionate punishment, Eighth Amendment type stuff, is the state constitution and the state rules, are they much different than what the federal courts set forth?
They're not different in any significant respect at all as far as the constitutions are concerned, the New Jersey Constitution and the federal Constitution. The significant difference historically, though, has been that the courts in New Jersey, the New Jersey Supreme Court, of course, being the highest court and leading that field, has consistently in the past defined the Constitution and issued rulings that were broader and more protective of the Bill of Rights and of the individual freedoms than, in most cases, than the federal Constitution.
I see. Now, how about the with respect to mandatory minimums on certain crimes? Can you tell our listeners how they apply and why a mandatory minimum is attached to a particular statute?
Over the course of the years, there have been occasions where the sentencing laws, sentencing statutes have been changed to provide for mandatory minimums. They were imposed for drug cases in certain instances where certain mandatory minimums were involved, and more significantly, with regards to a law which is known as the No Early Release Act.
Mhm.
I don't have off the top of my head, Bob, exactly when that came in. It's
Mhm.
probably a good 20 years, maybe somewhere
Yeah.
in between 15 and
Yeah.
20 years.
Right.
But that significantly changed matters as far as sentencings are concerned. And then with mandatory minimums, something that is known as the Graves Act,
Mhm.
named after the old Patterson mayor Frank Graves, who then
Sure.
became a senator,
Yeah.
which regulates, which involves the gun laws.
Mhm.
And there were mandatory minimums set up under that. There's even offenses that combine drug and gun offenses when the two are involved that call
Mhm.
for more enhanced mandatory penalties, and sometimes even mandatory consecutive terms
Right.
in situations where normally a concurrent term might be imposed because they were related to the same type of activity.
Mhm.
And that's been the biggest change, like I say, through those developments.
Okay. Well, you know what? I have to go back to the 1980s. It was an organization called FAMM, FAMM, Families Against Mandatory Minimums. And, for the past few decades, they have really tried to, I don't know, motivate politicians or actually get some word out there that a lot of these mandatory minimum sentencing schemes actually hurt society. And I want to go, you and I have had a conversation with respect to what the Attorney General has put out on April 19th, a directive letting prosecutors know that they should now look to waive certain mandatory minimum sentencing guidelines in cases. I really would love to hear your experience, your prediction on what this will have as far as an impact on prison systems, society, because there's a lot of people out there that just see nonviolent drug offenses as you know, eh, something not punishable, warranting, as much prison time that has come down the pike and has just filtered into the system, keeping people there for years. I wanted to get your opinion, especially as, a trial attorney. You've been around for more than a couple of days, Greg. So I really want to get your opinion on what you think of this.
Geez, thanks for reminding me, Bob, how long I've been around. I appreciate that.
Sure.
Yeah, mandatory minimums, of course, have been subject to debate. I know you mentioned how 20 years ago there was some feedback against them. To me, what has happened a lot with the laws is that legislatures have caved in more and more to public opinion,
Mhm.
and really the public misperception about how rampant things are and how the system favors defendants, which is really not true.
Right.
And it's manifested itself then in tying the judges' hands,
Mhm.
and requiring certain sentences. And it looks like maybe, just maybe, we're starting to turn the page a little bit. Bob, New Jersey went back and forth for years and years regarding the death penalty.
Mhm.
And eventually it abolished the death penalty, primarily because it was determined that, despite, again, public or common perception, it was not a deterrent to
Mhm.
crime as everybody
Right.
touted it to be, and it was applied disparately, as far as especially for along racial terms,
Right.
and so that's been 20 years again, perhaps since
Yeah.
it was abolished.
Yeah.
You would have hoped and thought that maybe that would have spurred more of a movement towards getting rid of mandatory minimums, mandatory sentences for all types of crimes, because the same type of concept applies.
Right.
It is not shown to be a deterrent, and it's not proven to be that. And again, historically, it's been decided that the court system, as much as it tries to be fair, has through statistics shown that it's applied disproportionately.
Sure.
What's happened here now is with regards to the drug laws that you're talking about. Again, keep in mind how narrow it is. We are talking about non-violent drug offenses.
Right.
There's 6 that are categorized in that the directive that you were talking about on April 19th. They're specified in there, and it is a start.
Sure.
For sure. What it basically did is as a result, of course, to some extent, an outgrowth of the legalization of marijuana and certain other changes that have become necessary now as a result of that. Like I say, I guess it spurred a little bit more of a re-examination of these things, and did away with mandatory minimums, both for cases that are coming up now and even applied retroactively to individuals who were given mandatory minimums for these types of offenses before. And it established a process, a pretty extensive process, whereby they can get immediate relief from that. It still allows the prosecutors to make an application for more than the minimum term that a person would serve. But now, like I say, it's a burden. The state has to prove that the aggravating circumstances far outweigh the mitigating circumstances, and actually has to get permission from the Division of Criminal Justice to make those kinds of applications. So they're putting a pretty tight clamp on that and trying to eliminate them.
Well, that's where I was going to go, and not to interrupt you, but I want to stay while you have this flow going. That's what I wanted to ask you because of your experience. Taking someone in, let's say they received a mandatory minimum for one of the statutes, that put them away.
The nonviolent offenses.
Yeah. Yeah, and now bringing someone back into court, let's say either on a post-conviction matter or I don't know if these would fall under quote illegal sentences now. What would be your recommendation for anyone who is looking to challenge or at least hook their wagon to this directive and possibly get in and get a either reduction of sentence or try to gain to get a little lesser time than what they were originally sentenced to?
Yeah, well, again, this directive does talk about a process whereby even through the court system, to identify those individuals whose sentences involved the mandatory minimums, to bring them back into court.
Right.
Again, I have the directive in front of me. It's a number of pages. I can't find the particular section right now about that, Bob, but I can tell you that the directive not only said from here on in, we're going to do away with these mandatory minimums, except under very limited circumstances and change in the process, but took steps to make sure that those who are serving sentences now under that are able to get review. So the court system is going to try and identify them. A particular individual basically only has to send a letter or that to just bring their situation to the attention of the courts. The prosecutor is, again, required then to basically agree to a reduction unless of the mandatory minimums, unless, again, they feel that the aggravating circumstances for that particular individual in case far outweigh the mitigating ones, and then they can argue in court that the mandatory minimum should remain. They can't think a person could not be given more than what, even in that situation, couldn't be given more than what they did. We know that under double jeopardy terms.
Mm-hmm.
But the directive makes it clear, though, like I say, that those should be very, very limited circumstances. And again, to individual prosecutors or counties basically have to notify the Division of Criminal Justice that they're making that application. So you got a second level of review on it. So it seems like it's a very concerted effort to do away with them. Don't forget, normally a person is eligible for parole after serving 1/3 of whatever the term is.
Right.
The mandatory minimums can increase that up to 50%. Sometimes even a little bit more, and like I say, of course, we know under NERA it changed it to an 85%. I mean, it significantly changed parole eligibility.
Yep.
Of course, these don't apply to NERA offenses now. Again, it's only the nonviolent drug offenses for now, at least.
Right.
But it's go ahead, Bob. I don't mean to dominate it, but it's interesting.
No, listen. I am looking to you for the nuts and bolts of this, and honestly, you're making some very fluid and logical statements for our listeners to understand. So please,
let me just follow up with this then, Bob, because it's in the field. In November of 2019, there was a commission that had been formed, and they issued its first annual report, which recommended the elimination of mandatory minimums for nonviolent drug offenses. And that commission included the Attorney General, the Public Defender's Office, the President of the New Jersey County Prosecutors Association, the Chairman of the State Parole Board, as well as representatives of the governor and legislative leaders of both parties. So this was a comprehensive commission. And basically they found that mandatory minimum laws, now this is in general, this is not specifically talking about just nonviolent drug offenses, but in general they found that mandatory minimum laws have not simply fueled the significant increase in the state's prison population, of course, but have also contributed to the stark racial disparities found in our prisons. And like I say, it's that kind of finding, Bob, that to me should be the impetus to continue on from nonviolent drug offenses to other types of crimes, and eliminating mandatory minimums and allowing the judges, who are very responsible individuals, to be able to make decisions about individual defendants in individual situations. I mean, after all, isn't that what justice is all about?
I listen, Greg. I everything you're saying there is just so, it's captured in real time. So my last question to you is something that I'd like you to run with, because you obviously have represented nonviolent drug offenders, and you're seeing today that, like you mentioned before, marijuana is now legal. It was supposed to be the enemy of the gods. And all of that thunder that politicians would use, we are now looking at some states are allowing for the possession. They haven't legalized it yet, but they're allowing for small amounts of possession of cocaine, heroin. Do you see us finally, as a society, addressing drugs as an illness, like we would look to alcoholism, and do any of your clients come back to your head as you're, thinking about this subject, and people who have been locked away for inordinate amount of times for maybe small possession? What are they around? Have they overdosed? I mean, I know it's a pretty shotgun blast question to you, but I just want to get your thoughts before we finish up today.
Well, I think, Bob, more than anything, this trend that's finally beginning. Okay, and pendulums, we know through historically they swing back and forth. So
Mhm.
finally, to me, the pendulum is swinging forward. If we're talking specifically now about drug offenses, and again, not just marijuana but other drugs,
Mhm.
where the pendulum is swinging. New Jersey has now what is known as a
Mhm.
drug court program. It's been in existence for a while now. There's been more recently a greater emphasis on making people eligible for that program
Mhm.
because it recognizes that, again, most drug offenses and most other offenses are connected with drug related issues, with substance abuse problems.
Mhm.
And the goal in drug court is to focus on treatment, on rehabilitation, on getting to the root of the matter,
Mhm.
to correct the situation, as opposed to just putting someone in jail for a while,
Sure.
and then eventually they're going to come out. They're going to come out even less prepared
Mhm.
to deal with society, with getting a job, etc., and more easily fall right back into the same type of behavior and not have the help that they need necessarily to address the underlying problem. So there is again some movement. Some would say perhaps maybe a little too slow, but
Mhm.
at least in the right direction now for those types of charges to, to take the focus away from just imprisonment, which
Mhm.
is not solving anything, which is very costly, and trying, like I say, to get to the root of the problem.
Right. Right. Greg, thank you so much for being on Greater Good Radio.
That's quite all right. It's been my pleasure, Bob. Thank you very much. It gives me an opportunity, as you can see, to vent out a little bit also.
And we're
Um,
just really glad to have you.
yep,
Thanks a
yep.
lot.
Thank you very much.
Take care.
Bye.
Your home is the most single important investment of your life. Making the right choices when improving or remodeling that home can't be left to chance. For over 5 generations, Standard Tile has set the standard in product line, product knowledge, and service. Whether you're remodeling a kitchen, bathroom, or if you need help with design, make Standard your first choice for quality you deserve. Visit Standard at 316 Route 10 West, East Hanover, New Jersey, 973-884-4933, or visit their website at www.standardtilenj.com. There may come a time in your life when you'll need an attorney. Whether it's a car accident or slip and fall, you'll want a professional with experience you can trust. Competence and reliability is what you'll find at the law firm of Hack & Rose. The attorneys at Hack & Rose, with offices located on the 10th floor at 112 Madison Ave in New York City, are dedicated to vigorously protecting the rights and interests of those who have been hurt due to the negligence or recklessness of another party. And the firm consistently achieves the top results in the state of New York representing accident victims. At Hack & Rose LLP, our accident lawyers have the knowledge and experience necessary to assist clients in their pursuit of compensation to cover medical bills, lost wages, and other losses that can result from a sudden accident. If you're interested in pursuing litigation or in need of support after you've been a victim of medical malpractice, the experienced and knowledgeable New York personal injury attorneys of Hack & Rose are prepared to help you more fully understand your legal rights and options. You can call Hack & Rose at 646-916-3890 or visit their website at www.hackroselaw.com for further information. Next up, we're going to talk to Alex Shalom of the ACLU, which is the American Civil Liberties Union. Thanks for being on Greater Good Radio, Alex.
My pleasure. Happy to
Alex,
be here.
could you please tell our listeners who you are, what you do, and more importantly, because I am just a huge fan of the American Civil Liberties Union, what you folks do and how it differentiates from maybe just a regular attorney-client type of case where an attorney is representing a defendant.
Sure. So I work at the American Civil Liberties Union of New Jersey, which is the statewide affiliate of the American Civil Liberties Union, the ACLU. The ACLU is a nonprofit organization that's been around for just over 100 years now, since 1920. The state affiliate has been around since 1960. And we are an organization that is dedicated to preserving the rights protected by the Bill of Rights, by the 14th Amendment, the important civil liberties, those kind of most important constitutional rights. So we deal with First Amendment issues where we take on the right to free speech and the right to assembly and separation of church and state. We deal with Fourth Amendment issues where we're trying to protect people from unreasonable government searches and seizures. We deal with protecting the equal protection of people's rights. We try and prevent cruel and unusual punishment, prevent excessive bails, things like that. And so to your question about how things are different from a normal attorney-client relationship, we're a nonprofit organization and we don't charge for our services. So when we represent a client, we do so for free. But other than that, the relationship should be very similar to a relationship that an attorney and client have.
Okay, well, and thank you so much for that, because I just think it's, I know firsthand from actually working with you folks on certain matters, just the importance of an organization like yours to, if nothing else, be an overseer or at least to try to challenge some of the unfairness that is embodied in the system. And that said, I want to stick with punishment, with youthful offender status. You folks filed as amicus, and I would like you to explain what an amicus is, on State versus Zuber and State versus Comer. If you could give us a synopsis of what the involvement was there and what the argument was with respect to punishment.
Sure. So let me first say we were amicus, which means the full Latin term is amicus curiae, or friend of the court.
Okay.
Which means you don't represent either party. You just are telling the court what you think the law is or what the law should be.
Right.
And so in Ricky Zuber's case, so that was State versus Zuber, we were amicus. We were a friend of the court.
True.
In State versus Comer, which is the companion case, we represented James Comer. I'm representing James now for 6 or 7 years. And both of those cases raised a common issue, which was the U.S. Supreme Court has told us in a case called Graham versus Florida and a different case called Miller versus Alabama, that that juveniles are different in the context of punishment, and they can't be treated the same as adults, at least as it relates to the most serious punishments. And so they had, in a previous case, a case called Roper versus Simmons, said juveniles can't get the death penalty under any circumstances. Juveniles are categorically excluded from capital punishment. But then in Miller and Graham, they went a little further, and they said, whenever in Graham, when a child has been charged with a non-homicide offense, and the judge cannot, under any circumstances, sentence that child to life in prison without the possibility of parole. And then in Miller, what they said is, nor can a child charged with a homicide offense receive a mandatory sentence of life in prison without the possibility of parole. And so Comer and Zuber were New Jersey's first interaction with that jurisprudence, with those U.S. Supreme Court cases. And what the New Jersey Supreme Court was tasked with answering is, how does that rule, no life without parole for juveniles in most situations, how does it apply when the sentence imposed is not called life without parole, but the practical impact is that the young person will die in prison because the sentence is so long? So just imagine, a 16-year-old gets a 1,000-year sentence. Well, it doesn't say life without parole, but we know with a practical certainty that person will not live for 1,000 years. And so Ricky Zuber had received a sentence of 110 years 55 without parole
Mm-hmm.
for a non-homicide offense committed when he was a teenager, under 18.
Mm-hmm.
And James Comer received a sentence of 75 years, 68 3/4 without parole,
Mm-hmm.
for his role in a series of armed robberies, one of which led to the death of one of the victims. But James was not charged as the shooter. No one alleged that James had shot the person. What the state alleged and what the jury found was that someone who James was with shot the person. And so under the felony murder rule,
Mm-hmm.
James was convicted of felony murder and 3 additional counts of robbery.
Okay.
And so what the New Jersey Supreme Court said in those 2 cases was, we're not going to elevate form over substance. We don't care what it's called. If the impact is that a child is going to die in prison as a result of a crime committed as a child,
Mm-hmm.
the Constitution forbids that. And so the court ordered resentencing for James and for Mr. Zuber. And Mr. Comer's case, James's case, is actually back before the New Jersey Supreme Court, because when he was resentenced, the court did credit the experts who we had hired, who said that James had turned his life around, and James was no longer posed any threat to society any greater than the general population, and that he could be safely released today, keeping in mind that he had served already at that point more than 20 years, now more than 21 years. And the court credited that and resentenced him, but said, I think I'm still bound by the law to give you a 30-year sentence, despite the fact that the experts have found that you could be safely released to society.
This is a good jump-off point. I don't mean to interrupt you, but while it's in my head, and I want to ask you specifically, we're discussing these 2 cases and youthful offender status and sentencing. What does the state of New Jersey recognize? If someone is of the age of 18, but they have not matured mentally, I believe that the term is transient immaturity. How do you start to assess or qualify a defendant who's been involved in something like this to sentence him as an adult?
Well, so it's a really good question, and it raises some important contradictions in these cases, which is, we know that we treat kids differently, but we also know that the juvenile brain doesn't stop maturing on one's 18th birthday.
Right.
Instead, what the social science is very clear about is that people continue to mature and get rid of what you've described appropriately as the transient immaturity of youth until they're 25 or 26. And so really what we need to be able to do is recognize that when crimes are characterized by impetuousness, by susceptibility to peer pressure, by an absence of responsiveness to deterrence, those are often those transient qualities of youth. And we need to have a criminal legal system that recognizes when it's those hallmark features of youth that are at play, and treat those cases differently than ones that represent real kind of antisocial behavior from adults. Sure. And there is a movement in the legislature to create a mitigating factor that would be applicable in sentencing whenever someone under 26 commits a crime. Now, that doesn't mean that we excuse what they've done. It doesn't mean that they're not criminally liable for having committed a crime. It just means we take into account the person's age in determining what the appropriate sentence might be.
Right. And I'm so glad we're having this discussion, because my whole mindset, as you may know, I'm working with an individual who was involved in a unfortunate, horrible crime where someone was killed. He was not the shooter, but he was just a couple months after his 18th birthday. Now, my parallel here, or my argument, something I'm trying to advance, and I may not be using the correct legal term, but I'm looking at it almost as a position of collateral estoppel, because if the state of New Jersey, the legislature, and the Supreme Court, who makes the rules, they've decided that you are not mature enough to buy alcohol until your 21st birthday, wouldn't it make sense that you couldn't be exposed to an adult sentence of life with a 30-year parole disqualifier if in fact you're 18? You may not have the capability of understanding your actions or the proceeding against you. Is there anything relative to my statement there that would make you think?
Yeah, so absolutely. I mean, in some ways, this was something that the court grappled with in Roper versus Simmons and Graham versus Florida and Miller versus Alabama, which is, why would we draw this arbitrary line at 18? And what the court said is, because we draw arbitrary lines all the time, right? We draw the line at 18 for buying cigarettes and buying pornography and voting in federal elections and so forth. But I think that the bigger point is not that the line draw is arbitrary, but that it's not moored to the social science, and that the social science would agree that a client who is 18 years and 3 months old also exhibits the transient immaturity of youth, and so should have an opportunity to go before a fact finder, a judge, a jury, whomever, and make their case that their youth influence their behavior.
Okay. And I have to just include this recent decision, because this is exactly where we are, what we're discussing with respect to sentencing. This past Tuesday, the Supreme Court of the United States they delivered a ruling on Jones versus Mississippi, which deals with transient maturity, deals with life without parole issues when juveniles are involved. But I can't really adequately discuss the entire ruling because it's only a 1-hour show. But I wanted to get your opinion to see if you have gone through this, because this is the most Judge Sotomayor wrote a blistering dissent on what Judge Kavanaugh wrote, and with respect to, and I hope I'm pronouncing this right because it's a Latin term, stare decisis.
Stare decisis.
Stare decisis. Okay, I was 50% there.
Pretty good. And so, my Latin is weak. So
okay, all right. So that said, I really wanted, because this was almost like 2 steps backwards. No,
it was. I mean, it wasn't almost like it. It was a real retreat by the court from the bold rule that they set forth in Miller, and then a case that followed it called Montgomery, which said Miller was retroactive. And what Jones did really was to take the wind out of the sails of this movement and to say, look, we have this rule that says judges have to consider youth, but we don't really mean it. They can give lip service to it. They don't have to make it a meaningful inquiry. They don't, in fact, have to first find that the young person is permanently incorrigible before deciding that the person can be condemned to die in prison. And what Justice Sotomayor was talking about in her dissent was, what the court really did was said, hey, look, we have a new makeup of the court. Justice Kennedy is gone from the court. Justice Ginsburg is gone from the court. And because of that, the power of the court is different. And so we're going to change the rules. But rather than saying that, they pretended that this was consistent with their prior cases. It was an absolute retreat from the prior rule of law. But they, since they didn't want to be seen as craven and political and partisan, they said, oh, this fits within the old box. It doesn't fit within the old box, but there's hope, Bob. And I want to just be clear on that, which is, since Miller, the trend is moving away from these draconian sentences for children. And 25 states have effectively banned life without parole or the practical equivalent of it through their legislative or judicial processes. Mm-hmm. And so that is the sort of trend that is relevant for Eighth Amendment inquiry. When we try and figure out if a punishment is cruel and unusual, part of that inquiry is the unusual nature of it. How rare is it? Yeah. And the fact is, these sentences in many states are becoming rarer and rarer. And nothing in the opinion in Jones forecloses a state like New Jersey from saying this is a barbaric punishment and we don't want to impose it on children living in our state.
Alex, I can't thank you enough for being on Greater Good Radio with us. I appreciate you taking the time. And please give my best to Tess Borden, who, so people out there know that she's an attorney with your organization, a very fine counselor.
She is indeed, and I will pass it on. And it was my pleasure to be here. Thank you.
Thanks, Alex. Take care.
Take care, Bob.
The warm weather is rapidly approaching and things are starting to open up. Time to get to the beach. So, it's time to shed those pandemic pounds we've packed on from staying home. That's only one good reason to join Lavalette Personal Fitness. Lavalette Personal Fitness focuses on personal touch. For 13 years, they've provided their clients with fitness programs seeking to achieve their goals for health and well-being. Lavalette Personal Fitness offers guidance in weight management, fitness for seniors, orthopedic exercise, and just plain good old working out. Don't wait to get into the best shape of your life. Talk about convenience. Lavalette Personal Fitness is the only fitness center on the Barrier Island. Call Gabby at 732-250-2185 or stop by and check out the facility at 501 Grand Central Ave, Lavalette, New Jersey, 08735. Or just pull us up on Facebook.
Some more, the others can do it, just try to go through with it. Thoughts in my mind, they don't flow, they just arrive. Why can't I figure it out? They come at you teasing, there must be a reason. Why can't I figure it out? Sometime, cause he's not really trying. You know deep down that he's not college bound. It's not make pretend, I just can't comprehend. Why can't I figure it out? Inside I'm burning, but not really learning. Why can't I figure it out?
Well, that's it for our show today, folks. Join us next week on Greater Good Radio. And as always, I just wanted to give a little shout out to Q, Percy, V1, Black Just, Hussein, Minaya. See you next week on Greater Good Radio.